Okay, we move on to 4.4, legislative advice for the incoming council. Mr. Green.
Thank you, Your Worship. I'll ask our corporate solicitor, Mr. McCaddy, Nigel McCaddy, to come forward and run you through this item. This item is, I was going to say procedural, but it's something that's set down in the legislation that we have to do at the first meeting, so it does sound a little bit boring, but it's something that we have to tick the box and go through.
Good morning, Mr. McCaddy.
Hello, can you hear me? Thank you. It could potentially be slightly dry, and I'm not sure how much applause taking you councillors through this is going to get, but this is very much an overview. I understand you will have received some introductory packs which will contain more detail. So if I'll just go through and I'll highlight some points. Your Worship, I take the item as read. I please encourage you, if you do have any questions as we quickly go through it, to stop me and ask the questions now. And of course, I'm more than happy to take questions away and provide the information to you after the meeting. So, the Local Government Act is obviously the key guiding act for councillors. It provides council with a degree of flexibility compared with the previous Local Government Act 1974, and that is that the council has what's called a power of general competence to do whatever it needs to do to achieve its purpose. Of course, that comes with a trade-off, and that trade-off under the 2002 Act is that there is a requirement to consult with the community, particularly in relation to those decisions which are of significance. I'd also make the point there that whilst there is a power of general competence, this doesn't extend to matters of a regulatory nature. So when we're talking about enforcement matters or bylaws, for example, the council is very much constrained by the provisions of the Local Government Act. So just something to keep that in mind. There are clearly two purposes of local government. The first is the enabling of community democracy, and the second is meeting the needs of communities for infrastructure, services and regulatory functions. There's very much an emphasis on cost effectiveness, as those returning councillors and new councillors will no doubt be aware. And that reference is to delivering outcomes in a way that is most cost effective for households and businesses. And really that emphasis on cost effectiveness makes affordability, which is of course a relative concept to different communities, the bottom line for determining how these outcomes are delivered. On page 19 of the agenda item, I have highlighted the key principles which a council should have reference to when performing its role. And I felt this was important to highlight these just as a touchstone really for councillors to go back to as they're performing their role. It refers to matters such as conducting business in an open and transparent and democratically accountable manner. The council should make itself aware and have regard to the views of its communities. It should plan effectively for the future management of assets and so on. So that's in section 14 of the Local Government Act. So I'd encourage councillors, both continuing and new, to continually go back and review those principles. So that's the whistle-stop tour of the Local Government Act 2002. I'll move on to, which is a bit of a mouthful, the Local Government Official Information and Meetings Act, or LGOIMA. Now, the overriding principle of LGOIMA is that information held by council should be made available to the public. The idea behind that is that will enable more effective participation by the public in actions and decisions of local authorities and promote the accountability of both members and officials to the public. That said, there may be at times very, very good reasons for withholding information. And those factors include the privacies of individuals. It can include situations where the council is involved in sensitive commercial negotiations. It can include situations where there is some legally privileged material, which there's very good reason for withholding that from releasing to the public. I've referred to the interests of the individual. It should be noted the Privacy Act places strict limitations regarding the release of information relating to private individuals, and this must be seen as curtailing the general rule regarding the public access to information. I just thought I'd highlight a passage for you on page 20 of the item, which says any information marked public excluded or confidential should not be released to the public or discussed outside of the meeting concerned. Members must keep to the law. A member cannot choose when to obey rules regarding confidentiality and when to breach them. The constant and consistent observance of the rules regarding confidentiality is critical to the delivery of good governance to the community. And the item goes on to just encourage members, please, that if there is a question in their minds about the release of information they hold to a third party, that their query or request should be referred to the Democracy and Community Engagement Manager, Tina Jakes. Continuing on that theme, under local authority meetings and confidentiality, when the public is excluded by due resolution of the council, and when the council holds information confidentiality, then it is critical that the rules of confidentiality are strictly observed and maintained by the members of the council. This is reinforced by the standing orders, which you've referred to in your declarations today, which means that a breach of confidentiality provisions in the standing orders may potentially be an offence under the Local Government Act. So that's the importance which the Local Government Official Information and Meetings Act and the Local Government Act places on confidentiality. Right, moving to the Local Authorities Members' Interests Act 1968. Now this helps protect the integrity of local authority decision making by ensuring that councillors are not affected by personal motives when they participate in council decision making and cannot use their position to obtain preferential access to contracts. So these are really, I think we'd all agree, matters of common sense. The Act deals with two forms of interest, both a pecuniary interest and a non-pecuniary interest. The distinction is a pecuniary interest is more straightforward. It really deals with an interest that involves money. The more difficult one sometimes can be dealing with non-pecuniary interests, sometimes referred to as the appearance of bias. These rules around bias operate not only to ensure that there is no actual bias, but also that there is no appearance or possibility of bias. And the principle is, as we're all familiar with, justice should not only be done, but it should be seen to be done. And what's that really highlighting is perception is very, very important. A non-pecuniary interest is a difficult issue because it often involves matters, as I said, of perception and degree. The question you need to consider, which has been drawn from case law, is this: is there, to a reasonable, fair-minded and informed observer, a real indication of bias on the part of a member of the decision-making body, in the sense that they might unfairly regard with favour or disfavour the case of a party to the issue under consideration? If there is, the member should declare their interest and withdraw from the debate. The law about bias does not put you at risk of personal liability, but importantly, the validity of the council's decision could be at risk. The need for public confidence in the decision-making process is paramount, and perception can be an important factor. Move on now to the Crimes Act. Again, this is very much common sense. Under the Crimes Act, it is unlawful for an elected member or officer to accept or solicit for themselves or anyone else a gift or reward for acting or not acting in relation to the business of the council, or to use information gained in the course of their duties for their or another person's advantage or monetary gain. One of the outcomes of a conviction under the Crimes Act is that a member would lose their office. Going on to the Secret Commissions Act 1910, again, it's a matter of common sense which should be obvious to all. The Act basically establishes offences relating to the giving or receiving or soliciting of gifts or other consideration as an inducement or reward for doing or forbearing to do something in relation to the affairs of the council, or showing or having shown favour or disfavour to any person in relation to the council's affairs or business. Again, a conviction under the Secrets Commission Act would result in the member losing office. The Financial Markets Conduct Act 2013, it's not an act which is relevant at this time to the council because currently this council does not offer securities to the public. If it did so, then the members would be in the same position as a director, meaning that if there was some incorrect information going out to the public about the securities that were being offered, then the members could potentially be liable under that act. Moving on to the Protected Disclosures Act 2000, or the Whistleblower Protection as it's commonly referred to. Under this act, an employee, which includes members of the council by definition, who disclose information about a serious wrongdoing by a public sector organisation, are protected from civil or criminal liability that might otherwise arise from such disclosure and from retaliatory action against them. Now, there's some various requirements that the employee or member in this case would need to follow if seeking protection under that Act. The Council has a protected disclosures policy which is required to be followed if a member or employee was considering trying to seek protection under the Act. So please have reference to those, and I'm sure that'll be covered in your introductory material. Moving to personal liability of elected members. Section 43 of the Local Government Act 2002 provides an indemnity by the Council for elected members in relation to civil claims, that's both damages and costs, and in relation to criminal action, it provides indemnity for the costs arising from successfully defending a criminal action. However, the Local Government Act does provide for a theoretical personal exposure on the part of elected members in certain circumstances if the Council has incurred a loss due to actions of the Council. However, you'll all be pleased to know that as a member you have certain defences if you can prove that the act or failure which led to a loss occurred without your knowledge, or with your knowledge but against your protest made at or before the time when the loss occurred, or contrary to the manner in which you voted on the issue at a meeting, or in circumstances where you acted in good faith and relied on information or professional or expert advice given by a council officer or a professional advisor on matters which you reasonably believed were in that person's competency. So there's plenty of protection for you there. Moving on to the Health and Safety at Work Act 2015, something that's been in the headlines a lot in the last 12 to 18 months. And this provided a significant change to New Zealand's current health and safety legislation following the Pike River tragedy. The Act now allocates duties on those persons who are in the best position to control risks to health and safety, which is appropriate to their role in the workplace. One of the significant changes is to introduce a definition of officers, which includes any person occupying a position in relation to a business or undertaking that allows that person to exercise significant influence over the management of the business or undertaking. So that would include members. So whilst members have a due diligence obligation, as do other officers of the council, there is, you'll be pleased to know, an exclusion from liability for elected members However, of course, that doesn't exclude a member's obligation to exercise due diligence. And the lucky last, the Public Records Act 2005, which is to provide a framework to keep central and local government organisations accountable by ensuring records are full and accurate, well maintained and accessible. And really, the key message here is that in the conduct of their affairs, elected members may receive information directly, for example, from constituents, and members will need to consider whether that information needs or meets the definition of a local authority record, and therefore need to ensure that it's included in the council's records. So that's the whistle-stop tour of the legislative requirements. I hope everyone's still awake.
Yeah, we're still awake. I think the short message is to the councillors, everyone's just got to behave themselves. Is that right, Mr. McKetty?
Basically, well, that's a fair summary. I should have just said that, shouldn't I?
Okay, thank you very much, Mr. McKetty, but I think it is very important to go over those particular points that you've raised here. So, very happy that you've done that this morning.
Thank you.
Is that all we need? So we're just a recommendation?
That's all we need. Absolutely. So there's a recommendation there, Mr. Worship, but I guess the short thing there is we had to go through that by legislation, but the short answer is if you're ever in doubt, come and have a chat to one of us and we can help you out and advise you in the right place.
Okay, so the recommendation that the council receives a report entitled Legislative Advice to the Incoming Council. Would I have a mover, please? Moved by Councillor Park, seconded by Councillor Hickling. All those in favour, please say aye.
Aye.
Against? Carried.